The two biggest mistakes when creating your estate plan. The first mistake is not properly executing your will. A lot of people just type up the will, type up something, and do not get it executed according to Florida law. Usually Florida law says that a will must be in writing. It cannot be oral. You cannot say something to your family, your friends of what you want. It has to be in writing to be legally binding. The second thing is that you must sign your will in front of two witnesses, two attesting witnesses that witness your signature as it's written in the document. There's no legal requirement that a notary has to be present. The purpose of the notary is so that the document is notarized, especially with what we call the self-proving affidavit. The witnesses do not need to show up to court in the event that you pass away and the will is introduced to court. The second mistake when creating your estate plan is not using an attorney. There's many traps that make it so that your intentions do not get carried if you do it incorrect. One of the biggest traps is Florida homestead law. There's many restrictions when it comes to homestead. Homestead law says that if you're married, you can only give your property to your spouse. And there's further restrictions if you have minor kids. If you use an attorney to create your will and the attorney helps with the notarization, then there's more legal weight to the testimony of the attorney at the moment that he or she introduces her testimony in court saying that you had capacity to sign that will. It's very difficult, and as an attorney, you can disbar if you have a client sign a document that does not have the legal capacity, the required legal capacity to sign a will. If you have any other questions regarding estate planning, make sure to post them in the comments down below, and see you on the next video.